Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I am here every Sunday from 8 to 9 a.m. on these stations to bring landowners valuable information that you need regarding the natural gas development here in Pennsylvania. So whether you're listening on the way to the gym, whether you're listening with your morning coffee, or any other way, or perhaps maybe you're operating your heavy machinery and listening, I appreciate you joining me here today, and I'm pretty excited about the show. And I say those things because I know we have a few listeners who do that regularly. So I want to talk about today a lot of, I think, very interesting topics. So really stick with today's show because I'm going to bounce around a little bit. I want to talk about apportionment at the end in the last segment of the show. So I really encourage you, make sure if you're going to tune in and stay in today, or if you're going to tune in, stay in today, because I think there's going to be a lot of interesting subjects, and feeling pretty energized. So I'm looking forward to today's show. I think we have a great list of things to talk about. Again, I am Attorney Doug Clark from the Clark Law Firm, and I represent landowners and only landowners for such items as gas lease negotiations, pipeline and water line agreements, royalty and royalty deduction issues, more and more estate planning every week, more and more. And also another thing I want to talk about just kind of briefly here at the beginning, represent clients and landowners with respect to unitization issues. Was your property unitized correctly? Are you receiving the correct credit for your acreage within a unit? And real quick story on that, just something this week. This is an example. When you get your division orders, you definitely want to check this out, and you want to check out your numbers. You want to make sure they're correct. Now, another thing I saw this week, I don't think that you need to pay somebody $200, for example, to check your division orders. I think that's a bit much, but it's something that I've seen recently, and I just want to say I don't think that you need to do that. But what you do need to do is make sure that you're getting the proper acreage, and that your decimal interest, which is the number, the ultimate important number, I shouldn't say that, there's several important numbers, but probably the most important number is you want to make sure that your decimal interest, or your interest in that well unit's production or unit production, is correct. Very, very important, because if it's not correct, then you're not going to be paid your royalties properly. So you want to make sure that that number is correct. Now, another document, they call them DPUs, which stands for Declaration of Pooling and Unitization. So I'm a person, I can't stand whenever people use these abbreviations and these long terms, and it makes them sound that they're smart and they know something you don't know. It's just because it's a term that they're familiar with and you're not. And one of those terms that I see in the oil and gas industry is this, when they say DPUs. Another thing that drives me crazy is the LOD or LOC. You hear that, you think, oh, wow, that must be something fancy. Well, in reality, a DPU is the Declaration of Pooling and Unitization. An LOD would be very fancy stuff here, limits of disturbance. How far of an area, or how wide of an area, or large of an area will the company disturb with their surface operations? LOC, same thing. Limits of clearing, or limit of clearing. How far are they going to clear? How many trees are they going to cut down? So yeah, it sounds all fancy. LOC, LOD, DPU. Well, they're not really that complicated terms. You just need to understand what these abbreviations stand for. So I want to talk here at the beginning, because this is a great example of something that's going to be very significant, I think, for this particular landowner and client. So, okay, landowner comes in and says, I don't know, I have, in this case, it was about 100 acres, and says, I'm not sure, can you find out information about these other about 20 acres that aren't unitized, and we would think that they should be unitized. So we were able to get a copy, and you can get these at the courthouse. You can go on a website called landex.com. That's LANDEX.com, and you can actually go there in most counties. Not every county, but most counties, you can go to that website and you can access the the court files and what's recorded at the courthouse, under your deed and under your property. You can also look at other people's as well. So one of the things that I think is very important, if I were a landowner and my property were unitized and I was getting royalties, I would want to get a copy of the Declaration of Pooling and Unitization, or DPU. I'd want to get a copy of that. And there's a bunch of legalese at the beginning, but what's really, really important for you, the landowner, is that DPU, or Declaration of Pooling and Unitization, that's filed at the courthouse. There's going to be a map there, and there's going to be like a sketch which is going to show what the size of the unit is. That's going to be contained in there. It's going to list all the different parcels that are included in the unit. Usually it's going to have the names of the individuals or the owner of these parcels, and it's also going to say how many acres that each person or parcel has in the unit. So what do I mean by that? So if I'll take this example. So in this client's case, we say, okay, let's look at the DPU, Declaration of Pooling and Unitization. I'm going to pound that into you. So we look at the DPU and we say, okay, we can look at this map, and actually this person was in two different units. They were in the north unit and the south unit. So we'll call this, use my name here, Clark units. This wasn't the name, but just by example. So they were in the Clark North unit and also had some acreage in the Clark South unit. Well, in looking at this paperwork, it was clear, and by looking at these maps and looking at where one unit started and one unit ended, I was able to tell, geez, it is clear that this entire parcel, in this case it was actually two parcels, but it was clear that all of this acreage was contained either in the north unit or the south unit. And what I mean by that is, if this was a 100-acre parcel, then maybe 40 or 50 were contained in one unit, and the remainder of that acreage, part was in the north and part was in the south, but all of their property was clearly within these diagrammed areas where the units began and ended. So I said, geez, it seems very obvious that these unit maps that show where the units are located include all of your property. However, when we look at the credit that you're getting of your acres within these units, there's about 20 acres missing. So we look and we say, is there a way that we can explain that? And in this case, there wasn't. So it appears very clear that for some reason, and sometimes, look, it can just be human error. At some point, there's an individual who's entering this information into a computer, into a system, typing this information down. And there's a lot of numbers, there's a lot of names, and it can get complicated, and people can make mistakes. And we see that. And we get those corrected more than what you would think. Now, thankfully, this isn't something we see every single day, but it's something that we do see, and not just once, but have seen this several times, which also leads us to say, well, if we're seeing this several times and we're correcting it, how many times is this occurring where somebody isn't paying attention, or they're not calling me or somebody else? So I know myself that we've taken care of these issues several times. I probably at least 10 times at least, and those are just the people that have contacted me. So how many other times is this occurring out there? Again, I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. And if you miss any of today's show, if you're missing any, if you have to leave, say you're on the way to the gym and you're not going to be able to listen to the whole show, go check out pagasleaseattorney.com or pipelineattorney.com. But what we do is we update the radio show or update the websites. We'll put today's show on pagasleaseattorney.com. That'll be up tomorrow morning on Monday. So, okay, back to my story. Again, true story, changing these numbers just a little bit for ease. But so we look at these Declaration of Pooling and Unitizations, or DPUs, and we see that clearly these maps show that all of this landowner's property is contained within these designated unit areas. So when I then look to, in these DPUs, there's also an area that shows how many acres that this landowner is getting credit for. Well, it turns out, even though it's clear from the maps that 100% of their property is unitized, they're not getting credit for 100% of their property being located within these units. And actually, there was about 19 acres in total that they weren't getting credit for, which appear to clearly be within these units. Now, these landowners did not have a copy of these Declaration of Pooling and Unitization documents, or DPUs. They are of public record, and that's what I'm saying. You can obtain the copy, but sometimes it takes some work. They don't always send them to you. The companies don't, and typically, in my experience, they don't send them to everybody in the unit. So, had this landowner not realized, hey, what's going on? And their question was more of, hey, can you find out when we may get the rest of our property in the unit? And we were working on some other issues with this landowner. And I said, well, let me get this information. Let's investigate a little further. So it turns out, upon investigation, that there are about 19 acres are not unitized, they're unitized, but they're not getting credit for them. So it's something that we're working on correcting, and we're still in this process. But I strongly believe that this is going to end up where the landowner was being shortchanged. And again, I don't think this was intentional by the company. I think that somebody made a mistake. But thankfully, it was something that the landowner brought to my attention, just more of a question in this case. But sometimes they'll come to me and they'll say, hey, we think there's something wrong here. Can you look at this? And I do a lot of this work. So they came and they said, hey, can you investigate? But there again was more about, can you tell us when we're going to see this development, when we might be unitized, because we were working on a well site location issue. And I said, okay, well, and as I started looking, I said, something's not right here. So anyway, we anticipate that we're going to get this corrected, that this landowner who has been receiving royalties for some time has not been getting their fair share, or not even fair share, has not been getting what they have been owed in royalties. And specifically, they've had 19 acres, it looks like, and I think, again, this is going to be clear, that they've had 19 acres that have been in these units that they've not received royalties for. So I fully believe that at the end of this process, what we're going to do is we're going to recoup, or we're going to get back the money that not even get back, we're going to receive the money that they should have been receiving for some time now for these 19 acres. So they had 19 acres about 19 acres within these units, and haven't been getting royalties for those acres. So I believe we're going to be able to establish this clearly, that the company is going to go ahead and pay them, say, and I don't have the exact time, but say it was 1.5 years they haven't been receiving these royalties. So they're going to get a big check for, if this all works out, and I think it will, they're going to get a check for 19 acres of royalties for the past, say, 1.5 years. Then moving forward, what will happen is the company will have to amend the Declaration of Pooling and Unitization to reflect that actually this landowner has an extra 19 acres within these units, and moving forward, they're going to consistently receive royalties now for these 19 acres that they did not receive credit for. I want to stress again, we're still finalizing all of these issues, but it appears that this is going to be pretty certain at the direction we're going. So very important, as you can imagine, receiving 19 acres worth of royalties dating back about 1.5 years, then moving forward, always receiving the proper credit. Plus, think about this. There are only, I think, 1 or 2 wells drilled now. Over time, there'll be more and more wells drilled. You do not want to have 19 acres that you should be receiving royalties on, but are not receiving royalties because of an internal error at the company. I want to stress again, it's not something that I see every day, but it is something that I see more than once, several times. So you want to check, ways to check this. You want to get a copy of your DPU, Declaration of Pooling and Unitization. You want to check out those acreage. You want to also check out your division order. You want to look at how many acres you have, and you want to make sure that math is right. And you should, if you can't figure it out, you should get help with that. But it shouldn't cost you $200 to review a division order to check your numbers. It really shouldn't. Okay, I'm way over already. I'm Attorney Doug Clark. You're listening to All Things Marcellus. Stay tuned today because I'm excited about today's show. Remember, if you miss any of today's show, you can always go back to pagasleaseattorney.com. Make sure you check out pipelineattorney.com. I'm going to be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Reminder, if you need representation, you can always contact me directly at 570-307-0702. That's 570-307-0702. Again, representing clients for gas lease, pipeline agreements. Pipeline agreements, you cannot go with a pipeline. You cannot do a pipeline agreement if you do not get good quality assistance. I assure you it is always going to be worth it. If it's somebody who you trust, who knows what they're doing, you need to get assistance in these matters. Whether it's me or somebody else, please do not go through this alone because there are so many tricks out there that landowners are falling victim to, and you need to protect yourself. And if it's something that you don't have a lot of leverage and you don't have a lot of power to deal with, well, then a good attorney is going to tell you that. And you're going to make the best of that situation. You're going to do it efficiently, and you're going to get out. But you're going to understand your rights, and you're always going to be better off in that situation. So please, whether it's me or somebody else, make sure you're getting assistance for any of these contracts. These are industrial contracts. These are major contracts that are affecting you, your property, and in many cases for generations. So you must make sure that you're doing this right. We want to make sure that you are getting the maximum compensation that you can receive for these different agreements and for these different projects, but we also want to limit what the company can do. We want to eliminate surprise for you as a landowner. I receive calls almost every day with landowners who are surprised, that didn't think that certain activity was going to occur or could occur under agreements they've signed, only to be surprised later. They listened to the landman, believed the landman, and now they're surprised. You can't let that happen to you. You just can't let it happen to you. I see it way too much. Way too much. Remember, the landman's not going to come out there and be mean to you. They're always going to try to be nice to you. So just because the person's nice doesn't mean they're giving you a good deal. Please, landowners, please be aware. All right, step off my horse there for a second. Not my horse, but my box. I guess that comes from, there's always a joke with my wife and my kids that I get a horse, and I have a point, and I'll beat the heck out of it. So it can be dead, it can be buried, but I'm still beating that horse. And I guess the horse in this case that I keep beating is please do not make these mistakes. I see it all the time, and never is a landowner happy when they're surprised. Please don't let that happen. Also, now here I am. I got to get back on the box just briefly, and I have other things to talk about, but it drives me crazy. I'm seeing too many people sign for way below what they can receive. I've used this line. I tell my clients this. I say this on a radio show. I don't care about, it's not about the money. It's not about the money. I understand that. I truly understand that concept. However, if you have two contracts in front of you, one's on your left side on the table, one's on your right side. They are identical. Every single word is identical, except one of them gives you $50,000 when you sign. One of them gives you $100,000. Which one do you want to sign? So, if you can have more compensation under the same agreement, why would you not take it? And it's silly, but it's true, and you need to make sure that you are maximizing compensation. Do not leave $50,000 on the table. Do not do that. The other thing is, so many times people are not happy with where a proposed activity is going to occur on their property, or even that the company is going to operate on their property. If you want to know, you need to get somebody working for you who can say, listen, this is something that may be able to occur in your property, or hey, this is something you can simply say no to, or this is something that you can negotiate to receive higher compensation and to limit what the company is going to do. The number one thing that I see out there now, so please pay attention, is Landowners are being told that the company has rights to do things on their property, whether it be a road, a pad, a roadway, a pipeline, a surface facility. They're being told that they have the right to install or construct or operate on the landowner's property, and that is not necessarily true. And so landowners say, well, I'm stuck anyway. They can do it anyway. Where do I sign? And I'm telling you, landowners, many people, hundreds, and maybe, well, we'll just say in the hundreds of people are making that mistake, are being misled. You need to consult with somebody who knows what they're doing, who understands the lease language, to maximize your situation and to learn your rights. You need to do that. Please do that. Whether it's me or somebody else, you need to do it. It's the number one thing that I'm seeing occur. I see people giving up tens of thousands and even hundreds of thousands of dollars, and I see people having surface operations on their property who don't want them and who want to avoid them, but are believing the representations that the company is making to them, that the company landman is making to them. Not their representative, but the company's representative. The number one thing I'm seeing all the time, and it drives me crazy, and we need to understand this, and we need to do better from the landowner's side. If the company has the rights to do something, you can still, in almost every single case, make your situation better. Also, if the company has the right to do something under a gas lease, it's not the end of the world to say, go ahead, company, do it under my gas lease, but I'm not going to sign something else. Because in most cases, when you sign an additional agreement after the gas lease, in most cases, when you sign this additional agreement, you're giving the company more rights than what they have in the original gas lease. It's another show. I've done many shows on this. I'm going to do many more. And actually, it's one of the topics that I was going to try maybe to get to today, but I got on my soapbox. I'm beating the horse. I'm going to move on here now. But please make sure that you're getting assistance. Whether it's me or someone else, people are just buying into whatever they're being told, and you need to understand it doesn't work that way necessarily. Please understand that. Okay. Thank you for indulging me. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. And a reminder, if you need representation, you can contact me at 570-307-0702, whether you're looking for representation or you're looking for information. Check out pagasleaseattorney.com. Check out pipelineattorney.com. Revamp the gas lease site. I know, again, I'm a broken record on this, but working on the pipe site, but it's tough because there's so many different things going on. Very fortunate to be as busy as we are and trying to work on the site when I can, but I'm finding that I understand what my father used to say. He said there's only so many hours in a day, and I always drove me crazy as a kid and thought, boy, I'm never going to say that, but I find myself, I don't say it, but I find myself thinking it. And hey, Dad, if you're listening, I understand what you were saying. Okay, I want to go back now. I was talking at the beginning, and I'm going to finish out this segment on this some more and say there are a lot of things going on. Okay, I talked about pipeline agreements, roadway agreements, but many people, you have this kind of line of what we see occur, like a timeline where people are entering into the gas lease. Then there's a quiet period. Sometimes it's longer, sometimes it's not so long. Then you start to see the wells being drilled. You got the roadways, you got the well sites, and you have the pipelines. You have water lines. You have all this different type of activity that's starting to occur. Then, once the wells are drilled, then you start going into the royalties. So, skipping a couple phases here. But what we see is, all through this process, there are many issues that arise. And, unfortunately, many problems at times. So what we look at now, and I can go back, we can talk about leasing issues, we can talk about roadways, pipelines, well sites, but there's another set of issues that arise when you get into this unitization, where your property is placed in a production unit and you're going to start receiving royalties. You need to check. The most important thing from what I see is you need to check initially to make sure that your division order is correct, that you're receiving the proper acreage of credit in the unit that you have been placed, your property has been placed. I have seen many times, don't want to overstate it, I don't see it every day, but I see it a lot more than what you might think, where landowners are not given the proper credit. I have 3 or 4 files right now, I think, open in the office where we're working on these issues or wrapping them up, where landowners weren't necessarily getting the credit that they should have been getting, or their decimal interests were not accurately calculated in their division orders. And generally speaking, it's not the math that's wrong. It's the basis. It's the underlying information, meaning maybe they entered in their lease as the wrong amount of acres. In the case that I was talking about here in the first segment of today's show, in that case, the person had about 100 acres, but they were only getting credit for about 81 acres in the units, even though it was clear when you looked at the declaration of pooling and unitization documents called the DPUs. When you looked at those, when you looked at the maps, you could see that 100% of this person's property was located within these designated unit areas. However, when you looked at the DPUs, Declaration of Pooling and Unitization, when you look at those documents, you saw, hey, their acreage isn't adding up. Even though it's clear all of the acreage is contained within these units, they're only receiving credit for about 81 of their 100 acres. So we say, hey, company, let me explain what's going on. I always like to try to spoon feed it to the company to make it as easy as possible, because we don't want to just seem like, it's just some other complaint out there. We want to make sure we give you the details. We spell it out to you. We make it as easy as possible, so you're really going to look at it and it's going to be hard to avoid, and you're going to see right away, oh wow, it looks like we made a mistake. And those occur, and usually they're human error, where the person didn't enter into the system the information in the right way. Usually that's what we see. So in this case, it looks like this landowner this is just give an example, because the royalties were paying for a while, and I don't know, might have even been longer. But it's about, say, a year and a half. So for about a year and a half, they were being paid on 81 acres of gas rights when they should have been being paid on about 100. So it looks like the company will go back and reimburse them or pay them for the last approximately year and a half or so. They'll go back and say, okay, we weren't paying you, we miscalculated your acreage, so we owe you money. Well, that's nice. That's a nice check. But had these people never thought to look at this, and in this case it was a little unusual because we were looking at a different issue and just happened to catch this, but you should be looking to make sure that you don't have this type of problem. So in this case, we found this, and it looks like we're going to get it all corrected, and then moving forward, instead of having 81 acres of credit for being in this unit, they're going to have about 100. Well, that's going to change the way they're being paid in the future. That's a lot of money. So what I worry about is, okay, I've seen this happen before several times. So how about the times that this is occurring and nobody's checking? The landowner isn't looking at their decimal interest. They're not checking their division order. They're not looking at the declaration of pooling and unitization documents, so they're not seeing where there's a mistake. They're just thinking, okay, everything is good. Hey, I got a royalty check, everything is good. You need to check this information. Now, I'm not one of these people to say, we need to run out and hire someone to check every single check and go crazy here. We need to check to make sure, especially at the beginning, you want to make sure, and I'm not saying just quit then, but especially at the beginning, you need to make sure that you're getting the proper acreage as credit. You need to make sure that you're getting the proper division order interest. And if you don't know how to do that, you do need to get assistance. But it's not that complicated. It shouldn't be something. I just why I got fired up on this. I saw this consultant who wasn't an attorney, just some consultant that it had this line item bill. A client gave it to me and said, look at this, and charged like $200 to look at a division order to say the numbers are right. That's not appropriate in my mind. So beware of that kind of stuff. But you do need to see that your numbers are correct, that you're getting the proper acreage. And look, most cases you are, but if you aren't, it can be very substantial. So we need to check those things out. We need to make sure you're getting paid properly. And the companies, they're not trying to get one over on you in a case like this. This was an error. So you point it to them, you show them, hey, here's the error. They say, you know what, we're sorry about that. And here, let's correct it. They're not, and we correct these all the time whenever we find them and they're legitimate errors. It's always corrected. All right, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m. Check out today's show. You can go to pagasleysattorney.com tomorrow. Check that out as well if you missed any of it. And the show's dating back for some time. We're working on, I know I keep saying it, we're working on updating the shows. I've been doing the show since August of 2010. So a lot of information available, pagasleysattorney.com. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m. on these stations. Also have prior radio shows archived on pagasleysattorney.com. If you are in need of representation, I've been talking about it recently, doing a lot more with estate planning. I talked about the timeline before, where we see there's the gas lease, then we see the development contracts, then we see royalties, and we see royalty-related issues, working and representing clients in all phases of this process. Only represent landowners, no pipeline, no gas line or gas companies. What we're doing also is, I'm doing more now as I have more clients who are transitioning into royalties. We're looking at those issues, but also doing more with estate planning. And whether you're a past client or not, whether you're getting royalties or not, doing a lot more with the estate planning work. So if you're in need of representation, you can always contact me at 570-307-0702. That's 570-307-0702. Now I want to talk about a couple other things here. I want to talk about I'm not going to get into pipelines today. It's not going to be the big part of the show. I talked a little bit earlier about get a lawyer. If you have a pipeline situation, if you have any of these contracts, get a lawyer, whether it's me or somebody else. Please get a lawyer. People are signing terrible agreements all the time. Get a lawyer. Not going to be the rest of today's show. I'm going to leave that go. Okay, but I am going to talk about just briefly these interstate pipelines. Again, just briefly, this is important. We're getting a lot more calls and clients representing for these interstate pipelines, which are the pipelines that go from Pennsylvania to another state. We see them go across the state. There's a Sunoco. We have the Atlantic Sunrise. There's some other Williams in Tennessee. There's Transco. We see these, what I like to call, what I call at times FERC pipelines, because the companies apply for FERC approval, which is the Federal Energy Regulatory Commission. What happens there is this is a different situation, but this is a situation where you should also get representation. You need to understand your rights, because ultimately there is a strong likelihood that the company is going to ultimately receive or obtain the power of condemnation in eminent domain. But that's not the end of this process. You need to understand what your rights are. Now, one of the things that I'm seeing, and I want to stress, look, this is general information, not advice for any specific individual whatsoever. Just the general feeling that I have that I'm going to put out there. But I'm not saying that you should follow this because you've heard me say this on the radio show. I'm saying you should get your own specific advice. However, my overall impression is, I'm seeing one of these companies, they're offering people option agreements for these FERC pipelines, these interstate pipelines. And an option agreement says, we're going to give you a certain amount of money now for the option of whether to install a pipeline or not in the future. If the company gets this FERC approval, well, what's going to happen then is the company would have the right of condemnation, and they can go ahead and install this pipeline because they have what's called a certificate of public convenience from FERC, and they have this permission. Well, when they're talking about options, that's telling us generally they're quite a bit of ways from getting this FERC approval, and they may not even have applied in some cases. So I am very, very hesitant to recommend to anybody, yeah, you should sign an option agreement for a proposed FERC pipeline. I don't generally like that. Again, we need to have specific advice for specific people, but from my point of view, it is very, very rare that I would ever recommend, and I haven't yet, somebody sign this type of an agreement. Now, these companies are smart. I say this often. It's not their first rodeo. They're smart. They've done this before. So companies in these cases, what I'm starting to see now with these FERC lines, on occasion, we're seeing the companies putting out that carrot for you as the landowner. Now, it's not just in FERC lines that we see these carrots being dangled out there in front of the landowner. We see them in other places too. But I'm seeing this carrot of, hey, if you sign this pipeline right-of-way option agreement, here's this carrot of $3,000. We'll give you $3,000 as a bonus. And I just see this as this big juicy carrot out there. Now the question is how big is it and how juicy is it? But it's a carrot. It's something to entice you as the landowner. So I can just see these guys and girls sitting in boardrooms, wherever, sitting in conference rooms saying, hey, how do we get these people to sign? How do we get these landowners to sign these option agreements when we haven't even applied for FERC approval? Or we're years away, or at least a year away from getting any type of approval. How do we get them to sign? Well, let's give them a carrot. Well, what type of carrot should we give them? And then you debate how big and how juicy of a carrot you want to stick out there. Well, in this case, what we're seeing is about $3,000 carrot. So, hey, you want to sign this, and we'll give you $3,000, and we'll call it a bonus, and we'll act like this is some great gift that we're giving you because we're such nice guys and girls. Well, beware of the carrot. Beware of the carrot. Because when you sign something, you have to understand all of the terms of that agreement. Are you maximizing that agreement? What rights are you giving up? And here I am as a landman. I'll put my landman hat on. First thing you need to do is see that I'm very uncomfortable. But I put my landman hat on and I say, okay, Mr. Landowner, look at this. We're going to give you $3,000. It's going to be some bonus that we're giving now. We're not going to always do this. We're giving you this now as a bonus to sign early. This is an opportunity for you to get $3,000. It's going to happen most likely anyway, or depending on how aggressive I want to be. Look, ultimately this company is going to get eminent domain, and we're going to be able to do this anyway. So we're trying to be good neighbors. We're trying to be a good company. We're all about the landowner, and we want to give you this $3,000 bonus now for acting quickly. People who don't do this now are going to miss out on this $3,000 bonus. Well, now I put my landowner hat on and say, well, geez, I guess that sounds pretty good because it's going to happen anyway, and it's an opportunity to get $3,000, and then, who doesn't want $3,000? So, okay, well, where do I sign? Well, now you've signed. You're committed. They kind of put you in the book here, put you in the bank because they got you. And now, as time goes forward, they look and they say, okay, who have we banked? Who have we booked? Who have we signed? Now, most likely, and this is where it talked about, this is no specific advice, but I have a feeling that people who don't sign have a very good opportunity of making up that $3,000 bonus, that carrot, making up on that and actually doing better in the future. Now, again, I can't stress enough, this isn't specific legal advice. I'm not guaranteeing anything. That needs to be a discussion between you and your lawyer. You need to be looking at this, and you need to determine, what type of risk am I willing to tolerate, but also, what is my overall offer? There's all kinds of different factors. But if you're being offered $5,000 for a pipeline right-of-way agreement, I would be very, very slow to sign this type of an agreement. But again, you need to get personal, individual advice. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. on these stations. You can always check out pagasleaseattorney.com. Check out pipelineattorney.com. You need to be informed anytime you're considering any agreement by a gas or pipeline company. But on these FERC lines, on these interstate lines, we're seeing these in areas where people aren't really used to seeing this type of activity, because these lines aren't just limited to areas of development in Marcellus and Utica Shale areas of Pennsylvania. We're seeing these in areas where a lot of my clients now I'm starting to see they only have an acre or 2 acre small areas or lots. You need to understand your rights and you need to maximize the situation. But at the same time, I am very aware if you have an offer for a pipeline, or you're being offered, not that it's something that you want, but you're being offered, say, $5,000 for a pipeline right-of-way agreement across your property, or easement across your property. You don't want to have a $2,000, $3,000, or $4,000, or even a $1,000. Well, you don't want to have a big legal bill. You certainly don't want to end up losing money on this because you don't want the pipeline to begin with. But still, you need to understand your rights. You need to maybe have a consult, and this isn't to be a commercial, but you need to understand your rights. You need to see where you are. You need to get a plan together. And that's something I've been doing a lot recently with some of the clients with these FERC lines, developing a plan, talking about what we think may occur, assessing your individual situation. And remember, companies are smart. They put out these carrots out there. They say, hey, let's dangle this carrot in front of these landowners, and they're going to go out and grab it. However, you need to know as a landowner, yeah, maybe on some occasions, you need to go ahead and grab that carrot and start eating. However, in many cases, you need to just let that carrot dangle and don't take the bait. But the key is you need, as the landowner, to understand your specific situation, get a plan together, and do what's right for you in your situation. And I can't tell you, and nobody else can tell you, what's right across the board in any of these cases. You need to get specific advice for your specific situation. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m., and I will be back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And again, if you're looking for representation, I try not to make this a big commercial, but if you are looking for representation, you can contact me at 570-307-0702. That's 570-307-0702. I have clients all across the state of Pennsylvania, clients in Allegheny County now, Armstrong County, Greene County, all across Pennsylvania. So if you need representation, regardless of the distance, always please feel free to call at 570-307-0702. And I mean this. I can say I fully mean this. Whether it's me or someone else, please get assistance with these issues. People every day sign bad agreements, lose out on tens of thousands, hundreds of thousands, and honestly, sometimes even more. And not always about the money, but allow the company to have a roadway maybe on their property for 100 plus years when they could have said no. And the same thing with pipelines that they didn't want. Please get assistance. Make sure it's someone that knows what they're doing. There are a lot of nuances. There are a lot of technicalities in these contracts. You need to get someone who understands what they're doing, who has your interest at heart, which they always should, but understands what they're doing and can guide you to do the best that you can do under these agreements and to eliminate these future surprises. Too many times landowners call the office and say, well, I didn't think they could do that. Or the landman told me they weren't going to do that. Remember, look at these contracts, and almost all of them, you'll see a provision at the end of them saying something to the effect of, no matter what was said to you orally or verbally, during this process, or as long as it's not written in this contract, no other promises, statements, anything like that count. Now, it doesn't use that language. It uses legalese to make it seem like it's more just typical, nothing to pay attention to. But pay attention. Anything that's said to you that is not in that agreement doesn't matter. Doesn't matter. So make sure that you're aware of that. I am Attorney Doug Clark. You're listening to All Things Marcellus. I am here every Sunday from 8 to 9 a.m. You can also go to pagasleaseattorney.com tomorrow morning. Monday morning, we'll have the show up. Have other shows up there. Been doing the show weekly since August of 2010. August of 2010. Okay. I want to finish up this last segment. I want to talk about apportionment. Some people will say, what in the world is that? Please stick with this. Don't give up on this. Apportionment. Very important, which also gives you an idea of, wow, never heard of this maybe. And there's a lot of other things out there that you might not have heard of, and we want to clue you into these type of things. So apportionment, what in the world is that? Well, not every state does this, but Pennsylvania does. And what happens is if you have a lease, one of the things that I always try to do for various reasons is separate different parcels on your different oil and gas leases. So let's use this example. A landowner has 3 properties, each of them being 50 acres in size. So what happens is all 3 of these parcels are under the same lease. Well, when under the same lease, they might not even be touching or adjoining. They might even be in different counties, but they're under the same lease. So let's at least put them in close proximity. Say they're all in one single county, and maybe 2 of them are adjoining parcels touching each other, and the other one maybe is a couple miles away. So what happens is, if you sign a lease in this situation, 3 50-acre parcels, and they're all in the same lease, but they're different parcels. They have different tax map numbers. They're separate parcels. Well, what happens sometimes is you may see that one of the 3 parcels, could be 2, could be 1, could be all 3, but one of the parcels, we're going to say, is included into a production unit. And that parcel actually starts getting or being paid royalties because of that parcel being in the unit. Now, the other 2 in my example are not in the unit, but the one is. So, how does that work? Well, who gets the royalties? Now, here's what happens also sometimes. We'll see where, in this example, we have 3 50-acre parcels. We got now one starting to get royalties. Well, what happens sometimes is a landowner who has multiple parcels, maybe they sell one or give one to their children, or maybe give one to each child. Or what also can happen is they've sold one or more of these parcels. So what we see sometimes, I'm going to use this example. Say the landowner in these 3 50-acre parcels sold one of the 50-acre parcels, kept the other 2. Now we're seeing royalties are being generated because one of the 2 parcels that he kept, is now receiving royalties. Let's just say 2, it's only one of them. So say the 1 50-acre parcel that he kept, all 50 acres are placed into a unit. Could be less than that. But all of them are placed in a unit. The second 50-acre parcel that he kept, none of that property is in a unit yet. We hope it will be, but it's not yet. And the third 50-acre parcel that wasn't touching these or wasn't adjoining the first 2, he sold to somebody else, got a really good deal, wanted that money now. Well, now royalties start coming in. So this landowner is excited. He says, all right, getting this first royalty check, all 50 acres of my first parcel are in a unit. This is going to be really nice. However, all 3 parcels were under the same lease. Now, when he receives royalties, is he the only one who receives royalties under this one parcel? Well, the answer to that under apportionment, the concept of apportionment, is no. Actually, he shares those royalties with the individual that he sold the sold the property and the gas lease to in this example. So, under apportionment, hopefully I'm going to have people scratching their heads because then I'm getting my point across here, is you can have one parcel that's getting royalties, and say it's, again, my example, you kept a 50-acre parcel, that parcel now is getting royalties, all 50 acres. You kept another 50-acre parcel, that's not receiving royalties yet. You kept, and let's say this, let's say you gave that one to your child. So you kept one, it's 100% unitized, you're getting royalties on all 50 acres. The second one, second parcel, 50 acres, you gave to your son. The third 50-acre parcel, you sold to somebody else because you got a really good deal and you gave them the gas rights. Well, now, as your 50-acre parcel, you own it entirely yourself. It starts receiving royalties. Well, you know who gets royalty checks? All three people. Your son, who you sold the 50 acres to, the other gentleman who you sold the 50 acres to in the gas rights, even though their property is not actually producing gas, they're going to benefit from your royalties because all of the parcels are under the same lease. They're going to get royalties because all of the parcels are under the same lease, unless you've done something to prevent that. But generally, that's going to be the rule. Now, on the flip side, okay, that's the bad situation for most people. They don't like that. But on the flip side, now say that same situation. You have 50 that you kept. You gave another 50 acres to your son, and you sold 50 acres to a third person. Well, if that third person's property starts being, or is placed in a production unit, and they start receiving royalties, well, you're actually going to receive a share of those royalties because all of the parcels were under the same lease. Now, what's also interesting is, or what the other part is, when, say in this example where the other gentleman's property is producing royalties and yours isn't, but you're still getting a share of the royalties because they were all under the same lease and you're all parties to that lease, in the future, hopefully your acres are placed in a unit and they start producing royalties as well. Well, then you're going to share the royalties from your parcel with the other landowners, your son and the other third party in my example. So that's the idea of apportionment. Now, I could talk and get a lot more detail, but I want to give this general concept. So one of the things that I like to do is, we like to, because most people don't like that. You want to be able to, and think about this. Maybe you're not going to sell it to a third party. Maybe you have 3 parcels and you're going to give one to your son and one to your daughter. But you want to give it to them. So if your son's parcel gets royalties, your son gets those royalties. If your daughter's parcel gets royalties, then she gets those royalties. You don't want to have it where if one parcel is getting royalties, it shares with another parcel because they're all under the same lease. If you separate the parcels on the leases, that's one really nice way to make this very clean. In my first example, if you have a 50-acre parcel, you sell it to the other landowner, it's on its own lease, or other gentleman who's a third party who now owns this property. He or she, he in my example, has a lease, 50 acres, and it stands alone. So if your parcel starts producing, you don't have to share with this other person because the properties are not on the same lease. Now, maybe you don't care about that. That's fine too, but you need to understand something like this can occur. One of the things that I see is, and now let me say this, and I'm going to run out of time, but just recently I had a gentleman come to me and saying, hey, something's going on here. This company isn't paying me. I subdivided 5 acres and sold it to another person, and I wanted to keep my gas rights, and I told the lawyer I want to keep my gas rights. We sold it to this other person. Number one, the attorney appears to maybe have made a mistake and didn't do, according to the landowner, what this attorney was supposed to do. Again, you need to have somebody who knows what they're doing. Don't make mistakes. But this landowner had no idea about apportionment. So the 5 acres that he sold to another person, that's not producing gas, but his property is producing gas. But because of apportionment, the gentleman who owns this 5-acre parcel, he's now getting royalties, even though his property isn't in a unit. He's getting royalties because he bought property under a lease that all of the parcels were under this lease, and now he's getting royalties, and the first owner isn't happy about it. All right, that's apportionment, just a part of it. Sorry, I'm out of time. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Have a great week, everyone.